5, 4, 3, 2, 1. This is further fortified by the fact that the appellant has nowhere pleaded in his writ petition or in the appeal as to what was the source of his information about the alteration in the year 2013 except for a bald statement of rumor full stop. If his excuse of having no knowledge is accepted, then the same would continue till his age of superannuation, which fell later on, and, therefore, the appellant was under an obligation to plead before this court positively with supporting evidence as to how he came to know about the said alteration full stop. The appellant having failed to do so, he is clearly responsible for further lapses of 15 years in having filed the writ petition against the order of 1998 in the year 2013 full stop. In this background, the plea set up that the respondents had not submitted any proof of tendering of the information to the appellant should be read in his favor is unacceptable full stop. In the said background, the conclusion drawn by the learned single judge on laches cannot be faulted with full stop. Coming to the issue of the doubt about his age, it is evident that the appellant alleges to have gone for training in 1976, but no supporting evidence has been filed to support the same full stop. To the contrary, the appellant filed a school leaving certificate which has been discussed in the judgment of the learned single judge and was on record, which was obtained in the year 2013 and, according to the said certificate, the age of the appellant would be 16 years and not 20 years, which is reflected in the document relating to training of the year 1975 full stop. Thus, the claim of the appellant as also that of the department are both clearly indicative of the fact that the age depicted in the documents at the time of training was not based on any cogent evidence and was, therefore, speculative that reflects manipulation. Stop. This sort of attempted manipulation, therefore, cannot be read in favor of the appellant to extend any benefit to him, full stop. There is an attractive argument on behalf of the appellant in this regard, namely that even accepting that in 1975 he was 16 years of age, his date of birth could not be pushed back beyond 1957 and there is no basis to calculate the date of birth as 7th January, 1955 full stop. We may point out that in the respect of the legal position to establish the correct date of birth as asserted, the onus is one of the person who makes the assertion full stop. In the instant case, the date of birth was corrected in 1998, but it is the petitioner who asserts that his correct date of birth cannot be pushed back beyond 1957 full stop. The petitioner was not been able to do so in view of the law laid down by the Privy Council in the case of Robbins versus National Trust Company, 1927, appeal cases 515/1927 equal to AIIE reports 73, where the Privy Council ruled as under to assert that a man who is alive was born requires no proof full stop. The onus is not on the person making the assertion, comma, because it is self-evident that had been born full stop, but to assert that he had been born on a certain date, comma, if the date is material, comma, requires proof, semicolon, the onus is one the person making the assertion, full stop. The appellant has failed to discharge this burden, full stop. The appeal, comma, therefore, comma, fails and is hereby dismissed, full stop. It is here that we find a scope of an inquiry that could have been undertaken by the respondents, comma, but in the wake of the manner in which the date of birth of the appellant was incorrectly recorded at the initial stage itself, and further that the writ petition was filed after 15 years of the correction made in the service book, comma, we do not find this to be a fit case to reopen the issue in the discretionary exercise of writ jurisdiction, keeping in view of the aforesaid disputed facts that have been noticed by us herein above, full stop. The appeal, comma, therefore, comma, fails and is, comma, hereby, comma, dismissed. K.C. Jha, open bracket, Amreshwar Pratap Sahi, comma, CJ, bracket close, open bracket, Anjana Misra, comma, J, bracket close, AFR/NAFR, AFR CAV, date not applicable. Uploading date 2/7/2019, transmission date not applicable. This complete absence of explanation on the part of the appellant and the excuse setup of no proof of information being tendered to him cannot ipso facto lead to the presumption that the appellant got knowledge about this alteration only in the year 2013, full stop.